All rise.
Good morning, everyone, in and outside the courtroom. Before we start, and pursuant to my decision setting the date for this initial appearance, the court photographer is permitted to take a few photos for 1.5 minutes. And Madam Photographer, I would ask you not to take pictures of Mr. Krasniqi with the security guards. So please proceed. Thank you, Madam Photographer. Madam Court Officer, could you please call the case, please?
This is case KSC BC 2020-06. The specialist prosecutor versus Hashim Thaci, Kadri Veseli, Recep Selimi, and Jakub Krasniqi.
Thank you very much, Madam Court Officer. Before asking those present in the courtroom to introduce themselves, I would like to remind everyone of a few rules that must be observed at all times in order to make courtroom proceedings smooth. Please make sure you activate your microphone before speaking and you switch it off as soon as you finish. Talk slowly and clearly, as we have interpretation from and into Albanian and Serbian. Wait 5 seconds before responding to me or a party or a participant in order to allow the interpreters to finish the interpretation. What is said in this hearing is transcribed in real time and will be reflected in a transcript available to the parties and to the public after this hearing. I would also like to remind the parties that certain information in this case is subject to protective measures and confidentiality orders. This includes confidential information that has been redacted from the confirmed indictment as to the identity of certain individuals, dates, locations, and other information. Confidential information shall not be disclosed in open session. If any party or participant wish, we must go then in private session and refer to any confidential information only in that context. Now, I would kindly ask the parties and participants to introduce themselves, starting with the Specialist Prosecutor's Office.
Good morning, Your Honor, and everyone in the courtroom. Appearing on behalf of the Specialist Prosecutor's Office today are Specialist Prosecutor Jack Smith, Deputy Specialist Prosecutor Alex Whiting, Head of the Legal Advisory Unit Claire Lawson, Prosecutor David Harbach, and I am Alan Teeger, Senior Prosecutor.
Thank you very much, Mr. Prosecutor. Now I turn to the defense, and for the benefit of the public, I inform that the defense counsel is on video conference from Kuala Lumpur. Counsel, you have the floor.
Your Honor, Venkateshwari Alagendra for Mr. Yakub Krasniqi.
Thank you, Ms. Allegendra. If at any time during this hearing you have a problem with the connection, whether it's to hear or to see anybody in the courtroom, immediately wave with your hand or say something so that we can fix this problem. And I would adjourn the hearing if needed, so to make sure that you're always in a position to follow, listen, and see what happens in the courtroom.
I'm grateful, Your Honor.
Thank you. And for the record, I also note that Mr. Krasniqi is present in the courtroom. Now I turn to Madam Registrar, please.
Good morning, Your Honour. Fidel Madonlan, Registrar.
Thank you, Madam Registrar. And for the record, I'm Nicholas Guillou, pretrial judge for this case. The accused is appearing today for the first time before the specialist chambers, following the indictment confirmed against him. Mr. Krasniqi, would you please rise? Can you tell us your full name?
Yes, I am Yakub Krasniqi. I was born on 1st of January 1951. Kosovan.
Let me now move to the procedural history of the case. On 26 October 2020, in my capacity as pretrial judge, I confirmed the indictment submitted by the specialist prosecutor against the accused, charging him with 6 counts of crimes against humanity, namely persecution, imprisonment, other inhumane acts, torture, murder, and enforced disappearance of persons, and charging him with 4 counts of war crimes, namely arbitrary detention, cruel treatment, torture, and murder. The accused was arrested in Kosovo on November 4, 2020. He was transferred to the detention facilities of the Kosovo Specialist Chambers in The Hague on the same day. Mr. Krasniqi, before we proceed any further, I have to make sure that you can follow the proceedings in a language that you can understand and speak. Can you confirm that you understand and speak Albanian?
No microphone for the speaker. Of course, I am Albanian. I speak and understand very well Albanian.
By this, I am satisfied that you can follow the proceedings in Albanian, a language that you understand and speak, in accordance with Rule 92 of the Rules of Procedure and Evidence. If at any moment in the course of the proceedings you are not receiving interpretation, please draw my attention to it immediately. Now, allow me to explain the specific purpose of the initial appearance for the benefit of the accused and those joining us in the public gallery and following the proceedings online. Today's hearing is not a trial. No evidence will be presented or debated, and the guilt or innocence of the accused will not be discussed or decided. The purpose of this initial appearance is regulated by Article 39 of the law and Rule 92. According to these provisions, as pretrial judge, I shall have the charges in the confirmed indictment read to the accused in a language that he understands and speaks, confirm that the accused understands the indictment, satisfy myself that the rights of the accused, in particular his right to counsel, are respected, inform the accused that within 30 days of today's hearing, he will be called upon to admit guilt or plead not guilty on each charge set out in the indictment. If the accused wishes to do so, he may immediately admit guilt or plead not guilty. And finally, I shall also set other dates as appropriate in performing my functions as pretrial judge. I expect the parties to adhere to these matters, which I will address in turn. Should either party wish to discuss any other matter not explicitly foreseen in the context of this initial appearance, they are invited to do so in writing by making a filing before me. First, may I ask you, Mr. Krasniqi, to confirm that you have received the confirmed indictment dated 4 November 2020 in a language that you understand and speak.
Yes, I have received the indictment, part of it, on 4th of November 2020, and upon my arrival in the detention facility, I received a redacted version of the confirmed indictment. It is in the Albanian language. I've read it and I do understand it.
I will now ask Madam Court Officer to read out the charges in the confirmed indictment as foreseen in Article 39 of the law and Rule 92. Madam Court Officer.
Thank you, Your Honor. In the confirmed indictment, the specialist prosecutor charges Mr. Jakub Krasniqi with Count 1, the crime against humanity of persecution punishable under Article 13(1)(h) of the law. Count 2, the crime against humanity of imprisonment punishable under Article 13(1)(e) of the law. Count 3, the war crime of arbitrary detention punishable under Article 14(1)(c) of the law. Count 4, the crime against humanity of other inhumane acts punishable under Article 13(1)(j) of the law. Count 5, the war crime of cruel treatment punishable under Article 14(1)(ci) of the law. Count 6, the crime against humanity of torture punishable under Article 13(1)(f) of the law. Count 7, the war crime of torture punishable under Article 14(1)(ci) of the law. Count 8, the crime against humanity of murder punishable under Article 13(1)(a) of the law. Count 9, the war crime of murder punishable under Article 14(1)(ci) of the law. And count 10, the crime against humanity of enforced disappearance of persons punishable under Article 13(1)(i) of the law. These crimes were committed between approximately April 1998 and August 1999 at a number of locations in Kosovo and northern Albania, including A. Bare, Bajgore, Lapaštice, Majac, Potok and other locations in Podujeve, Drenot and other locations in Rahovec municipality, Beriše Mountains, Lapušnik and other locations in Drenac municipality, Ferizaj and other locations in Ferizaj Municipality, Gilan in Gilan Municipality, Jablanice in Đakovo Municipality, locations in Kačanik Municipality, Klečke and other locations in Lipljan Municipality, Likoc and other locations in Skenderaj Municipality, Mališeve and other locations in Mališeve Municipality, Voljake Cave in Kline Municipality, Novo Berde in Novo Berde Municipality, Zlaš and other locations in Pristina Municipality, Prizren and other locations in Prizren Municipality, Suha Reke and other locations in Suha Reke Municipality, and locations in Viti Municipality, and B. Kahan and Kukes in northern Albania. 3. The crimes under counts 1, 2, 4, 6, 8, and 10 were committed as part of a widespread or systematic attack directed against the civilian population in Kosovo and northern Albania from at least March 1998 through September 1999. In particular, these crimes targeted opponents who were perceived to have been I. collaborating or associating with Federal Republic of Yugoslavia forces, officials, or state institutions, or 2. Otherwise not supporting the aims or means of the Kosovo Liberation Army and later the Provisional Government of Kosovo, including persons associated with the Democratic League of Kosovo and persons of Serb, Roma, and other ethnicities. 4. The crimes under count 3, 5, 7, and 9 were committed against persons not taking active part in the hostilities and in the context of and associated with a non-international armed conflict in Kosovo between the KLA and forces of the FRY and the Republic of Serbia, including units of the Yugoslav Army, police, and other units of the Ministry of Internal Affairs, and other groups fighting on behalf of the FRY and Serbia from at least March 1998 to approximately 16 September 1999. 5. In relation to these crimes, there is a well-grounded suspicion that Mr. Krasniqi is criminally responsible pursuant to Article 16(1)(a) of the law for A. Committing as a member of a joint criminal enterprise the crimes under counts 1 to 10, or alternatively committing as a member of the aforementioned joint criminal enterprise the crimes under count 1 to 10 by being aware that such crimes might be perpetrated in carrying out the common purpose of the joint criminal enterprise and by willingly taking that risk, and or B. aiding and abetting the crimes under counts 1 to 10. 6. In addition, and in the alternative, there is well-grounded suspicion that Mr. Krasniqi is criminally responsible pursuant to Article 16(1)(c) of the law as a superior for the crimes under counts 1 to 10. Thank you, Your Honor.
Thank you very much, Madam Court Officer. Mr. Krasniqi, I wish to remind you that today is not the time to contest the charges, but simply to acknowledge your understanding of the charges. You will have ample opportunity to challenge the charges with the assistance of your counsel. Mr. Krasniqi, did you understand the charges contained in the confirmed indictment as read out to you by Madam Court Officer?
I want to mention a couple of issues, and I will try to be as brief as I can. First of all, I'd like to say that I was arrested on the 4th of November 2020. You call us joint criminal enterprise in the indictment. I would like to state today that never in my life, not in a single case, have I treated people in the way that I was treated from the building of the detention unit to this building. I've never treated people in my life in this way because it was never my aim to treat people like that, but it was war, and we fought against the Serbs who committed genocide in Kosovo. So I feel fine, and I wouldn't be in the guise of people who have committed crimes. I have fought Serbia politically, and I have never pointed at the civilian population or anyone like that. And you try in the indictment to divide Albanians into Catholics and Muslims. I am Albanian. I'm not Catholic. I'm not Muslim. This is offensive to me and to my country. Allow me now to express a couple of points in relation to the indictment. The qualification by the specialist prosecutor that we are a joint enterprise is, for me, my comrades, my family who have fought for a long time. This is an insult to us and to our nation, because we, for a long time, in very difficult circumstances, in life or death circumstances, we put ourselves in the service of creating our own state, in collaboration with the United States, with NATO, with the EU, and the United Nations. And we, all of us together, were a joint liberation enterprise and a state-forming enterprise, while a joint criminal enterprise are not only the Serbs in Serbia, but also their head in Belgrade and whoever supports the policies of Belgrade. I believe, and I believe strongly, that this is known by every educated citizen who is above 30 years old and lives in the countries of Western democracies, where they were raised and educated with the values of this world and the values of human freedom and rights. I don't want to speak at length today, but I would like to say that I was convicted by the criminal regime of Yugoslavia in 1981 and 1982. And they punished me because I was reading books, because I was speaking out, and I was against that regime. But believe me, they were more right than you here, for the reasons I am here today. This is a great injustice that has been done to me, and I will carry it. I will carry this burden on my shoulders, because our people has a saying that says, humans are stronger than rocks.
and what the rock did not bear, human people can bear. We have been done a lot of injustices, myself and our people, and there was no need for another injustice for this one. Of course, in other hearing sessions, I will say more about this. But I wouldn't feel right to be in the service of the criminal and genocidal policies of Serbia, which even Vukcevic, the Serbian prosecutor, said after the indictment was raised. He was a prosecutor from 2003. And the address, the true address of this masquerade is in Belgrade and its policies, wherever they are being applied.
Now let me inform you of your rights before this court. The law on the specialist chambers and the rules of procedure and evidence guarantee you a number of rights, and I will read out the most important ones today. First, you shall be presumed innocent until proven guilty beyond reasonable doubt. In the determination of the charges against you, you are entitled to a fair and public hearing, subject to any measures ordered for the protection of victims and witnesses. You have the right to be informed promptly and in detail, in a language which you understand, of the nature and cause of the charges against you. You have the right to have adequate time and facilities for the preparation of your defense, and to communicate with the counsel of your own choosing. You have the right to be tried within a reasonable time. You have the right to be tried in your presence and to defend yourself through your counsel. You have the right to have counsel assigned to you and without payment if you do not have sufficient means to pay for it. You have the right to examine or have examined the witnesses against you and to obtain the attendance and examination of witnesses on your behalf. You have the right to have the free assistance of an interpreter if you cannot understand the language used in the court. You have the right not to be compelled to testify against yourself or to admit guilt. You have the right to remain silent, and no adverse inference shall be drawn from your silence. You also have the right to make unsworn statements relevant to the case, and you may appear as a witness under oath. You have the right to lodge preliminary motions to challenge the jurisdiction of the specialist chambers, to allege defects in the form of the indictment, and to seek the severance of the indictment. You have the right to receive, within 30 days of today's hearing, the supporting material to the indictment submitted for confirmation. You have the right to receive all statements of witnesses whom the specialist prosecutor intends to call to testify at trial in a language that you understand and speak, namely Albanian. You have the right to receive immediately any information which may reasonably suggest your innocence or mitigate your guilt or affect the credibility or reliability of the specialist prosecutor's evidence as soon as the information is in his custody, control, or actual knowledge. You have the right to have all material and relevant evidence or facts in possession of the specialist prosecutor be made available to you before the beginning and during the proceedings. This right is only subject to restrictions which are strictly necessary and when any counterbalancing protections are applied. You have the right not to be detained for an unreasonable period prior to the opening of the case, to request review of decisions on your detention, and to appeal such decisions directly before the Court of Appeal. You have the right to appeal directly before the Court of Appeal a decision on preliminary motions challenging the jurisdiction of the specialist chambers. You have the right to seek leave to appeal all the decisions. Mr. Krasniqi, you heard the most important rights that you enjoy in accordance with the applicable legal framework of the specialist chambers. Do you understand these rights?
Yes, I understand them, but I'd like to say something about my defense. In fact, initially I thought I wouldn't take counsel. And that was my decision. And I was convinced that I didn't need counsel. However, it was the wish of my family and my friends to have a lawyer, for me to have a lawyer, and I accepted. Otherwise, I am convinced that I don't need a lawyer. I take no responsibility, not a single one, in relation to what I have been accused of, not in relation to acting or failure to act. My duties were public. My main duty was to be a spokesperson of the KLA. I also had other duties. I was a minister after the war and then a Speaker of Parliament. But what I did wholeheartedly was as spokesperson of the KLA. And whatever I did, everything I did was public. Not only in the Albanian language, but also in German, English, French, Italian. I was a spokesperson. I gave a voice to the fight waged by the KLA in very difficult circumstances. However, we were determined. We knew we were right to fight for our freedom, and of course, it was this right that gave us international support. Otherwise, we wouldn't have been able to liberate Kosovo and create the state of Kosovo. I am aware of that. But the acts that are alleged in the indictment, none of them stand. And in the days to come and months to come, I will bring concrete facts to prove that. But if somebody alleges that I spoke against the specialist chambers, I have to say this. In December 2010,
my question was, at this point, only if you understood your rights.
Your Honor, I would like to say that I have this grudge in me, and I know that I'm here, it's not right that I'm here, and injustice has been done against me. if anything that is said in the indictment is true, I would feel ashamed. I am here. My presence here is a big injustice. I have no responsibility to bear in relation to what is said there in the indictment. And this injustice that has been done to me is major.
I will now follow up on what you just mentioned about your counsel. I wish to inform that, according to Article 21(5) of the law, you may not represent yourself because you are currently in detention. So representation by a specialist counsel is mandatory. It is my duty as pretrial judge to ensure that your right to counsel is respected. To this end, I have noted the registrar's filing informing me of the appointment of counsel. And I think you've just confirmed that, even if you said that it wasn't your initial thought. May I ask you, counsel, if you can confirm that you have been appointed to represent Mr. Krasniqi?
Yes, Your Honor, I have.
Thank you. Mr. Krasniqi, do you have anything else to say regarding your counsel? Microphone, please.
Unë me avokatin kam biseduar.
I have talked to the counsel, and I believe that I'll be able to talk with her in the future as well. Like I said at the very beginning, I did not want to take a defense counsel, but because of the pressure by my family and my colleagues as well, at the end I decided to go for a counsel. So in this case, we are respecting the procedures set by the specialist chambers. Thank you.
I'm therefore satisfied that the accused is represented by counsel. I will now turn to the possibility for the accused to enter a plea, if any, in accordance with Rule 92. Mr. Krasniqi, within 30 days from today, you will be called upon to admit guilt or plead not guilty on each charged in the confirmed indictment. But if you wish to do so, you may choose immediately to admit guilt or plead not guilty. I would therefore like to ask you, Mr. Krasniqi, if you had had the opportunity to discuss the charged in the confirmed indictment with your counsel, and if you are prepared to enter a plea at this time. If it is the case, I invite you to stand up and plead.
Although I already have a discussion with the defense counsel yesterday, and we had an overview of the main counts in the confirmed indictment, like I said before this moment, and once again I wish to reiterate that for you, I do not feel guilty, nor do I feel responsible of any of the counts in the confirmed indictment. I feel guilty about nothing that is reflected in the confirmed indictment.
I don't know if it's your words or if it's a question with the interpreters. I heard that you feel not guilty. Can you confirm if you plead not guilty, or do you wish to wait for this formal decision for the 30 days that you can take to make this decision? Microphone.
I plead not guilty. I have no single blame, no single fault, and I don't know how to put it otherwise.
So that it's crystal clear in the transcript that you plead not guilty, and this point is now noted. You can sit, Mr. Krasniqi. Now, let me move to the working language of the proceedings. In the scheduling order for this initial appearance, I'd ask the parties to make submission on the working language to be used in the present case according to Rule 8. I will first give the floor to the prosecutor on this point.
Thank you, Your Honor. No need for any elaborate submissions. We see no reason to depart from the practice up to now. In fact, the contrary. So I think in a nutshell that captures our submissions on the use of English as the working language of this institution.
Thank you, Mr. Prosecutor. Counsel, what are your submissions on this question?
We agree to English, Your Honor, being the working language.
Thank you very much, Counsel. I will issue an order in due course on this matter. As indicated in the order regarding this initial appearance, I will schedule a status conference pursuant to Rule 96 to be held shortly after the initial appearances of the accused. The purpose will be to review the status of the case and to organize exchanges between the parties to ensure expeditious preparation for trial. Mr. Krasniqi, I wish to remind you that you have the right to attend these status conferences with your counsel. However, with your written consent and after receiving advice from your counsel, pursuant to Rule 96(2), the status conference may be attended by you in person with your counsel participating via video conference link, by your counsel with you, Mr. Krasniqi, participating via video conference link, or it may also take place in your absence, Mr. Krasniqi, with your counsel present or participating via video conference link. I would now like to ask the parties for their views on a suitable date for the status conference to be held on or after Wednesday, 18 November. Would the defense also be available to indicate whether it plans to participate in person or via video conference? First, Mr. Prosecutor.
We are available, Your Honor, at the court's pleasure, and that date is perfectly suitable.
Thank you, Mr. Prosecutor. Counsel, what are your availability, and if so, would it be in person or via video conference?
Your Honor, we are seeking 30 days minimum for the status conference. And to the extent that travel will be permitted from Malaysia, I intend to be present in person unless something extraordinary occurs that prevents me being there in person.
Thank you, Counsel. I'm afraid it will not be possible to wait that long because of the disclosure obligation of the prosecution. If we had to do it earlier than that, would there be any day that either would work for you or would be absolutely impossible? That's my first question. And the second question is, I know if you participate via video conference, there is a time difference. What would be the best moment in the day if we had to schedule it?
I will be available at the court's convenience, Your Honor, date and time.
Thank you very much, Counsel. This is much appreciated. And we'll try to, given the time difference, not to have it too late in the day.
Thank you.
But this is very much appreciated because, as you know, there are different defense teams and it will be difficult to accommodate for everyone. So this is much appreciated. You will receive a scheduling order that will include the agenda in due course. I will also ask the parties for written submissions on the topics of the status conference. I intend to schedule the date for these written submissions of the SPO by Friday, November 13th. and for the defense on Tuesday, November 17th. But you will receive everything in writing. And after the status conference, I will issue a decision on the specialist prosecutor's disclosure obligation in accordance with Rule 102 and on the redaction regime of the proceedings. At this point, I would like to ask the parties whether they have any other issue they would like to raise, and I remind the parties to give prior notice should any submission require the disclosure of confidential information so that appropriate measures can be taken. Mr. Prosecutor.
Nothing further from the prosecution, Your Honor.
Thank you. Counsel?
Your Honor, I request that hard copies of the basic legal documents of the specialist court be provided to Mr. Krasniqi in his own language. And we do intend to submit a filing on provisional release as soon as possible, Your Honor.
Thank you very much. This is noted. Mr. Krasniqi, I would now like to ask you if you have any issues you would like to raise regarding your arrest, transfer, or detention.
What can I say? What I believe is that the entire indictment related to myself in person, but probably this is something related to the procedures under the specialist chambers. However, I have to say that the procedures that have been applied in my case from the morning of the 4th of November up until the moment that I was brought to the chambers, in my opinion, are not appropriate. They are not suitable. They are not appropriate to me because I feel innocent. And there is no reason whatever to bring me before the chambers. However, I wish to say something else as well. So you know that there has been a tribunal for former Yugoslavia. And I think that you're well aware of the fact that there have been accused people from Kosovo in the Hague Tribunal. Myself, I've been called twice as a witness to the former Yugoslavia Tribunal, and I've said everything I've had to say out loud in that tribunal. Therefore, I think that if there was a single testimony, if there was a single fact to incriminate myself, I would have been sentenced by that tribunal. In other words, I see this as a last resort attempt, and I'm sorry to say that, but I have to. And I want to let you know that in 2006, the Academy of Science of Serbia already embarked on this attempt, because the Academy was the major part of the former tribunal, the ICTY tribunal, and they very much wanted to have this tribunal against Kosovo as well. And they managed to have this tribunal set in place by establishing this one ethnical chambers. However, I can say that there is no one above the age of 30 in Kosovo who does not know who has committed crimes and genocide. This is a huge injustice, and it hurts me profoundly. However, I do understand those people. I understand those that are present here, the way in how they're behaving to myself. So I'm not a criminal, I'm an intellectual, so I've been educated to serve as a teacher, but I've been obliged to fight for the freedom of Kosovo. However, when it comes to people, I have always been human towards people. I've treated them with dignity, and I have not even done the injustice that has been done to me by being brought from the detention to the chambers, controlling me several times on whether I was handcuffed or not. I mean, I've not even gone this far to any person in my life. I wish to highlight that you have procedures in place which are probably suitable to criminals, but they are not appropriate to myself. So the prosecutor and the prosecution office know of who I am. They have collected the books that I have written, and I have written a total of 15 books, and I feel good for that. But I feel really bad for all the injustice done upon me, and that's not a minor injustice, but it is instead a tremendous, a huge injustice. I wish to conclude by saying that from all the injustice that we've done upon me, from 6 o'clock in the morning of the 4th of November up until this moment in time, I've not ever deserved this injustice, and there is no one to be able to justify this injustice done on me.
Inform you that I will issue a decision ordering the specialist prosecutor and the registrar to reclassify their filings or prepare redacted versions, as the case may be, so that the defense has access to them as soon as possible. As you remain in detention, Mr. Krasniqi, I would like to inform you that you may challenge your detention on remand in accordance with Rule 57. This will be dealt with written rulings. This concludes this hearing. I thank the parties and the registry for their attendance. I also thank the interpreters, stenographer, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned. Thank you.
All rise.